Well, thank you everyone for joining us today for this webinar on pleas and sentencing in the Magistrates Court. For those that I haven't met, I am Tara Schultz, a Senior Associate in our Government Advisory team here. First, I'd like to begin by acknowledging the traditional owners and custodians of the land on which we're meeting today, the Wurundjeri people of the Kulin Nation. We pay our respects to their elders past, present, and extend that respect to all Aboriginal and Torres Strait Islander people attending today. The structure of this webinar is going through the process of a plea and sentence in the Magistrates Court. So firstly, we'll discuss how matters might resolve, including a duty that prosecutors have to resolve a matter early, the benefits of resolving a matter, and some of the considerations that go into how a matter might resolve. We'll then go through how to actually conduct a plea in the Magistrates Court for those of you who might not be experienced, including how to prepare for the plea, what sort of submissions you would be making on the plea, responding to defence material, and dealing with victims. And finally, the last part of the session will focus on sentencing, the role of the prosecutor on sentencing options that the court has, and a little bit of a discussion around an appeal and a rehearing of a matter. So firstly, resolution discussions. I think the first thing really to consider here is that the accused holds the right to plead guilty or not guilty. It's not up for the prosecutor to push a matter on to hearing or to really have any say in how the accused wants to progress. Once the charges are filed and our case is put forward, then the matter's really in their hands, whether they want to plead guilty or if they want to take it through to hearing. So that includes if they come with an offer to resolve the matter, whether it's to plead guilty to all of the charges or some of the charges. It's not for the prosecutor to reject that offer so that the matter goes to hearing. If they want to plead guilty, they can walk into the court and say, I plead guilty. And if the prosecutor hasn't engaged in that process, they lose any advantage they might have to negotiate an outcome. And when we talk about resolution discussions, we're not talking about plea bargaining in the sense that you might see particularly used in America, or what people would an accused might consider a plea bargain. It's an obligation on all the parties to resolve the matter at the earliest possible stage to avoid, the cost and time and effort of litigation. And any agreements that are made part of a resolution discussion are not binding on the court, but they are binding on the prosecutors. So what we're talking about here is if the prosecution says, makes an agreement with the accused that they'll withdraw charge 1 if the accused pleads guilty to charge 2, and won't say anything about sentence. The court may still ask the prosecutor to say something about sentence, or if the prosecution and the defence agree that all the parties agree a fine's appropriate, the court might still impose a different sentence, and the court's not bound by whatever discussions have happened between the parties. And it's also possible, particularly when we're talking about withdrawing charges, that the court may not accept what the parties are trying to do. Not quite in the same way that they'll just reject it outright and impose their own sentence, but if they don't think that the evidence meets a charge, they won't accept a plea of guilty on that charge. Just because a person pleads guilty to it, if there's no evidence to form the basis of that charge, or the charge is wrong in law, might have an error in it or something like that, the court's not bound to accept it just because the accused has offered to plead guilty to it. And that's a really important protection where we have self-represented accused or accused who really want to plead not guilty but don't have the experience in a court to indicate that, and they might say to the court, I just want to plead guilty so it goes away, but I didn't do it. The court can't accept a guilty plea in those circumstances because it's quite clear the person intends to plead not guilty. So moving on to talking about things to consider when having resolutions to discussions. And these are the things for the prosecutor to consider why it might be a good idea to resolve matters early. And the first thing is the availability of the witnesses and the admissibility of any evidence. This might be particularly important where the informant or the person who investigated the matter has left the organisation. So, you know, the person you'd be calling to give evidence no longer works for you and might be difficult to track down or be made available, or where your evidence, when you review it as the prosecutor, has some holes in it or might contain evidence that you don't think is going to be admissible. And in those cases, you want to resolve the matter rather than proceed to hearing and lose on those charges. Another important thing is that in a lot of these matters, an agreement to costs can be made as part of the resolution. So it's not ordinary that costs would be awarded to a prosecuting agency, and magistrates generally are quite unwilling to do it. And in the normal course of things, the police or Office of Public Prosecutions or a big prosecuting agency is not going to be awarded costs for successfully prosecuting someone, because that's just their job. But if you're an agency where prosecution is only one of the things you do, you are more likely to be successful in a costs application where you've successfully prosecuted an accused. But you have to understand that that is entirely discretionary and not sort of an expected outcome. So if you can get an agreement to costs as part of your resolution discussions, that's a really good outcome to recover costs rather than leaving it in the hands of the magistrate. A resolution discussion also allows you to roll up or do representative charges. And this is something that's quite useful if you have multiple breaches. So if there's something like a Food Act prosecution where there might have been hundreds of violations of the Food Standards Code, you might have, you know, your informant might have charged 20 or 30 different charges. On a plea, you can roll those up to one charge of breaching a particular standard, or perhaps one charge that represents a whole swathe of conduct. And you can only do that on a plea, and it brings down both the time and scope of the prosecution, but still allows for the full scope of the offending to go before the court in consideration of sentence. And it can be a really practical way of rolling up something, and it doesn't really result in the prosecution losing too much of their argument, but it is a big win for the accused to say, you know, that they're only pleading to one charge as opposed to 20, even if the actual facts of that charge are the same. And it can get things progressing rather than being stuck doing a contest on 20 or 30 charges. The other option with resolution discussions is to agree things like injunctions or other court orders, you know, disposal orders, forfeiture orders, licensing orders. You can agree those as being appropriate. Same with non-court orders. So if you have a power to issue a notice to comply or a different, an improvement notice or something like that in relation to the offence, that may be something that the accused consents to as part of an agreement. So, for example, they'll plead guilty to charge 1, charge 2 is withdrawn, and they'll, you know, counsel will issue a notice to comply that they'll comply with. And that can be a way to get a practical outcome, because a lot of one thing the court can't do on sentence is make any of those non-court orders. So if you want, you know, building works to be repaired, sorry, building works is a bad example because the court can issue an injunction in the course of criminal proceedings. If they've breached the Planning Act and you want them to do works and that you can't get those as a sentencing order. Same if they breached a local law and you want to use the notice to comply to get rectification, that needs to happen outside of court. And so resolution discussions where you agree to withdraw some of the charges might be a way to get that to happen. So one thing you do have to be careful of is autrefois acquis and double jeopardy, which basically means that you can't charge a person twice. Now, if a charge is withdrawn, it could be recharged in the future, but only if it's within time. So for most offences, we only have a year. So very often, if you're withdrawing charges, then that's done. It's not going to be able to be prosecuted again. And we also have to be careful that if you're withdrawing something or they're pleading guilty to something and there's an agreement about potentially issuing infringement notices or something, this can be problematic, where that infringement notice would be for an offence that they've already pled guilty to or already had dealt with before the court. because an infringement notice, if it was then taken to court later on, can't be for the same offence that they've already had dealt with. So you do need to really think it through and work out exactly what you're agreeing to and what the consequences could be in the future. Now, if you've either hammered out a resolution or they've just pled guilty to all the charges, we then move on to actually doing the plea. But I'll just pause for a second to see if there's any questions about the resolution discussions before we move on to the conduct of the plea.
Nothing has come through.
Excellent. Well,
if anyone does have any questions, if you could pop them into the chat, that would be great.
Excellent. So once the matter is resolved and we actually go before the court to conduct a plea, there's both important preparation that has to happen before you actually get to court, even if you've resolved the matter. The first part in preparing for a plea is to settle the summary. Sorry, I think we're one slide behind.
I'm just going to have to restart the presentation, so
Okay.
1 second.
So for a very basic offence like an infringement notice offence that's been contested, you may not rely on a summary. You might just allege the facts as charged, which is where the court will consider the matter and sentence on the basis of the particulars in the charge sheet. And that's probably sufficient for a simple infringement notice offence. But for anything more serious, you need to have a summary. And that summary is how you, as the prosecutor, put the case to the court on a plea. You don't tender the brief of evidence, all the statements and photos and witness statements and any other materials you have are not going to go before the court. It's all going to be in the summary. That summary has to be true and accurate to the facts, and it needs to be supported by evidence if called on. So you can't put something in your summary that you don't have admissible evidence for, because you have a duty to the court and your own ethical obligations to only put facts that are agreed and properly evidenced before the court as a basis from which they sentence. So you do need to take some time to settle the summary and make sure that it's supported by evidence, particularly if your summary hasn't been written by you and it's been written by an informant in preparing the brief. You'll need to go through and check and make sure that there's evidence to support all the things that you're putting to the court. And the contents of the summary might be something that you've settled in a resolution discussion. Defence might want certain facts out, or those facts, because charges have been withdrawn, certain sections of it might be relevant anymore because those charges are no longer before the court. So you need to go through and make sure that the summary only reflects the matters that are proceeding to the guilty plea, and that it's supported by evidence. You also need to consider whether you're going to call any evidence on the plea, or if the defence is going to. It's pretty unlikely for the prosecution to call any evidence, though you may want to tender some photos or something like that during the summary if it's agreed. And that can be really important in, building, planning, construction prosecutions where you've got a particular structure that you need the court to understand the importance of, or for impact. So if you're talking about, a Food Act matter where a restaurant is dirty, or, there were particularly horrendous images of dust and mold and animal droppings, and you, or the mistreatment of animals, and you want to put those photos to the court for impact, consider where and how you're going to tender those on your plea and make sure that defence knows that they're coming as well. Evidence that defence might call on the plea might be is usually they will call character witnesses and they'll give their evidence over by a witness, a character reference that's signed. When you're assessing a character reference from an accused, you need to make sure that the character reference indicates that they know that the accused is pleading guilty to a criminal offence, that they know it's going before a magistrate, because if a person's saying they're of good character, but they haven't actually got a character reference from someone who knows about the offending, it's of less importance. And it might be something that you want to raise on the plea that, the character reference was provided in relation to a job interview, not in relation to these proceedings. It's generally not necessary to sort of be that nitpicky. But if someone's really relying on their good character, but they haven't told the witnesses that are giving character evidence that they're facing criminal charges, it's quite important that you investigate the statements that have been made. Defence might also call psychological evidence to say that the accused has a particular mental illness and that affected their moral culpability. Usually that will be in the form of a report. And again, you need to interrogate that report and see what was told, what the actual conclusions of the psychologist are. If that psychologist is someone who frequently gives evidence in criminal matters and knows the appropriate processes and their obligations as an expert witness, or if it's just their treating doctor who maybe hasn't prepared things as thoroughly as an expert witness would. And you can bring that to the court's attention when it comes time to do the plea. But, you need to actually interrogate the materials you receive from defence. In terms of victim impact statements, so with the victim's charter, a person who is affected by a crime is considered a victim. So that means we don't need to have someone who's actually the victim of an assault or some sort of, trespass or something like that to give a victim impact statement. If someone's affected by offending, any type of offending, they could be considered a victim. And you have obligations under the victim's charter to ensure that they're aware of their rights to give a victim impact statement, which is read on the plea. They can attend court and read themselves, they can have it handed up to the magistrate, or you can read it on their behalf. And this will be particularly important in cases where you do have a traditional victim who's been injured or impacted by the offending, but it also may be that you have neighbours of building projects or people who have been adversely affected by a nuisance or something like that, that want to exercise that right. So you need to canvass with them if they want to make a victim impact statement and then provide it to the court if they do. Victim impact statements are in a particular form and the Department of Justice has those forms available and they need to be witnessed because they become part of the court record. So it's not just an email from the victim. Now, once you've got through all that, you want to settle on your sentencing submissions. And in the Magistrates Court, we're talking about usually a few lines. We're not engaging in detailed written submissions. So if that's necessary in your case, you need to do that. But most of the time in most Magistrates Court matters, you're going to have a short time to read your summary and make any submissions on sentence. That may include providing comparable cases. Most of the time, magistrates, if it's a matter that goes before the Magistrates Court all the time, parking offences, they know what the maximum penalty is, they know the comparable cases. It doesn't discharge your obligation to provide that information, but they probably won't need it. If it's something that doesn't come before the court very often, if we're thinking about if your agency doesn't prosecute a lot of matters, or if you don't prosecute that particular offence very often, then the magistrate's not going to have seen it before either. And you need to help them through the process by making sure they're aware of any similar cases and the particular sort of concerns and public interest matters involved in a particular case. Once you've got all that done, you need to file your documents through EFAS or eDocs. They're the process now for getting materials before the court. Emails to the registry will often be redirected to file through those systems. So make sure that you've got everything done Now, when you appear at a plea, it'll either be in a list where you have heaps of other matters and you'll just smash through, or it might be a separate plea listing. But either way, the process is pretty much the same. You indicate to the court that the matter's going to be a plea. They'll usually ask the defence to confirm that. You'll be asked to read the summary or the charge if you're just proceeding on the particulars of the charge, and then you put forward any sentencing submissions. If you are relying on a written summary or any other materials, make sure the court has a copy of those materials before you start reading. And generally intend to say everything that you want to say in one go. You may be invited to respond to any defence submissions, but particularly if it's a very serious matter that has its own separate listing, it might run a bit more similar to a county court plea where, the sides will take turns and give you opportunities to respond to each other. But for most matters, particularly if you're in a long list, you're going to get to stand up, say your plea, then defence will get to stand up and say their part, and then the magistrate will sentence. So you need to make sure that you've got everything ready to go and say at the start. And they've just included a quote here from Barbara, which is it was a pretty scathing case about how the prosecutor approaches sentencing submissions, and really outlines that the job of the prosecutor on a plea is to submit the facts, the relevant principles of law that are to be applied, and what's been done in comparable cases. And it overturned a practice that had been happening in Victoria, and overturned a decision in a case called McNeil Brown, that the prosecutor could offer to the court an available range of sentences. So say to the court, it's appropriate in this case to sentence within, these range, fine to or imprisonment or fine, that sort of thing. And what Barbara said is it's the opinion of the prosecutor on sentence is not appropriate. They can make submissions as to the law, and they can assist the court in its duty to consider sentencing practice. They can say the facts of the case and any submissions of law, but it's not for them to point out to the court what the sentence should be. And the court should not pay heed to any, the court's process is independent. The court has to exercise its own discretion, guided on the law by the prosecution, not to accede to any suggestion by the prosecutor of what the sentence should be. And the proper conduct of the prosecutor in discharging this duty and not making inappropriate suggestions is really important, because if the prosecutor doesn't do that, if they tell the court what to do and then the court does it, that's a ground for appeal. So once the prosecutor's done, we have the defence part of the plea, and this is where they'll put their matters in mitigation. And there's some key cases that they might refer to that you should be aware of. And the first one is Verdens, which is a case about the moral culpability of an offender with a mental illness. And in that case, we're talking about different ways that a mental illness might impact a person's moral culpability for offending, or make time in prison more difficult for them. And the court is bound to consider that and to mitigate the sentence appropriately. If someone's relying on Verdens, they need to call psychological material or a report to support that. It can't just be on submissions from the defence solicitor that the person has a mental illness and Verdens should apply. They have to specify which of the particular limbs apply, and they have to give some evidence. So if they start to raise that sort of thing and they haven't provided psychological evidence, it's perfectly appropriate to step in and seek that evidence, or point out to the court that the submission isn't supported by evidence. Another important case, which is lessening in its importance now, is the case of War Boys, and it talks about COVID and the utilitarian value of a plea in circumstances where the court is so backlogged. In that case, a very significant discount was given on a sentence because of both the situation in prison due to COVID and just generally the value of an early guilty plea when the courts are so backlogged. So they may raise that. The impact is a lot less in circumstances where there's not imprisonment being imposed. And now as the courts start to clear some of that COVID delay, it will become less important. Another important case is the case of Bolton, which refers to, basically it discusses just punishment and the fact that things that are less than imprisonment, particularly community corrections orders, are punitive on the accused because they impose restrictions on their movement, they require them to go to courses, they require them to report to the Department of Corrections, and so those things may be just punishment, even in very serious cases. And finally, doesn't come up too much in the Magistrates Court, but it is an important case, and that's Bug Me, which talks about really severe disadvantage in childhood, having sort of a permanent impact on a person's moral culpability. And again, if these sorts of submissions are raised about a person's mental health, their life, the impact that it's having on their functioning, those need to be supported by evidence. They can't just be submissions on instruction from the defence solicitor. And if those specific sorts of things don't apply, you will generally always hear these sorts of mandatory submissions from defence, which go to what the judge has to consider, and they're about the accused good character. And that comes up, that will almost always come up in matters, regulatory matters, where the person probably hasn't ever been in the criminal system before and has no criminal history, then defence rightly, and the court will rely on the fact that they're a person of good character. If the person does have criminal history, particularly for similar types of offending, that should be pointed out. You'll have to file the criminal record as part of the materials, and so it should be, brought up if there's submissions around good character when the criminal record doesn't support that. Also, defence will raise an early guilty plea. You just have to accept that. There is a discount on sentence for pleading guilty early, which, you may receive criticism from informants or from other people in your organisation saying, well, why did you accept the guilty plea if they're going to get a discount? And one important consideration is the discount applies from basically when the plea's offered. So if they offer an early guilty plea to all of the charges or some of the charges, and then a hearing proceeds for whatever reason, and they are found guilty only of those charges, or if they've offered to plead guilty to all of the charges, and they're found guilty of all the charges, the court will still consider that they offered to plead guilty and for whatever reason it didn't proceed. And so they will apply the discount, and they will be particularly critical of the prosecution if they offered to plead guilty and on some charges, a prosecution said, no, we want to proceed on all charges, then they are not found guilty of all charges. If they're only found guilty of what they offered to plead guilty to in the first place, the discount is going to be given because of that early guilty plea. It's not going to be as significant, but it will still be given. So that's sort of the court's way of forcing prosecutors to consider the early resolution. And finally, the other issue that will be raised as a mandatory consideration is their cooperation. So whether they participated in made admissions in a record of interview, whether they cooperated with investigators, whether they've done any rectification works, those sorts of things. And they go to their ability to rehabilitate. So following defence submissions, if the prosecution has nothing to say in reply, then the court's going to proceed to sentencing. And in sentencing, there is no requirement for the court to hear from the prosecutor. It's no miscarriage of justice if they don't. So if you want to be heard on a particular point, you need to have said it in your plea submissions, because the magistrate, once they move on to, after they've heard from defence, they're probably not going to call on you again unless there's a particular matter that they have a question about, and they'll just proceed to sentence. The types of sentences that can be imposed, firstly, there's diversion, which is a separate process that requires the consent of the prosecution, and that will have been sorted out before you get to plea. So I've just included it here because it is a type of sentence, but it's not going to be occurring in a plea without prior consent. The first and least punitive option is proven and dismissed. So the court finds the charge proven and dismisses it with no penalty imposed. Next one is an adjourned undertaking. So that's where the court adjourns the matter for 6 or 12 months and imposes a number of conditions that the accused has to do in between that time. So they may have to pay, make a donation to charity, undertake a behavioural change program, make a contribution to the court fund, comply with a notice, something like that. And then if they've done all of that within, make an apology to the victim, if they've done all of that within the period of the undertaking, at the end of the time frame, then the charge is dismissed. It is a serious thing to commit an offence whilst on an adjourned undertaking because it is a type of sentence. So if a person commits a subsequent offence while whilst on an adjourned undertaking, it has an impact on things like bail, but it also has an impact on the sentence on the next offence. So because one of the conditions of the undertaking is to be of good behaviour. So it will breach the undertaking and they'll fall to be resentenced. You know, they won't get the charge just dismissed at the end of 12 months. So if you have an offender that's on an adjourned undertaking, you or the informant needs to make sure that they comply with the terms. You can't just, oh, they got an adjourned undertaking, the matter's off my books. It'll have a new hearing that'll be administrative, like you won't have to appear, but there'll be a hearing listed for 12 months, and you need to check in and make sure that somewhere close to that new hearing that they've complied with all of the conditions. After an adjourned undertaking, you have a fine, and a fine can, both an adjourned undertaking and a fine can be imposed with or without conviction. A fine is pretty straightforward. There'll be a maximum penalty listed for the offence, and the fine imposed will be somewhat less than the maximum penalty or the maximum penalty. If you are prosecuting almost any offence, the penalty unit is indexed and set and is available on the Department of Justice website. Goes up every year. It's about $184. If you have a local laws offence, the penalty unit is $100. And that's just a little quirk of the reforms to the Sentencing Act, that the local law offences were not, do not follow what a normal penalty unit is. So if you've got a local laws offence, you may need to point out to the court that the penalty unit is only $100. There's some magistrates and judicial registers aren't aware of that. Community correction order is a punishment with which can be imposed with a fine or with a term of imprisonment where a person is subject to supervision by the Department of Corrections for a period of time in the community. And firstly, they'll be supervised, so they have to have regular meetings with the department and their case manager. And it can also impose fairly onerous conditions on them. So they can be required to undergo unpaid community work, to undergo drug and alcohol treatment, mental health treatment, to engage in behavioural change courses, a whole range of programs that the department can put them on, which are aimed at rehabilitating them and preventing further offending. Community corrections orders can go for 2 years, and you know, complying with the conditions is the sentence that they're undergoing. Again, breaching a community corrections order is an offence, punishable by up to 3 months imprisonment. So if you have an offender on a community corrections order, your informant needs to be aware of any further offending, and just keep an eye on things. So the Department of Corrections itself prosecutes the breaches. And finally, for some of you, you'll have offences with terms of imprisonment that may be imposed, and that's the most serious offence that a court, the most serious punishment that a court can impose. So any sentence less than imprisonment can be imposed with or without conviction. And conviction is entirely at the discretion of the court. If the court doesn't impose a conviction, it is still a finding of guilt. So for the purposes of any orders made that require a conviction, so such as a destruction order for a dog that says upon a finding of guilt, it doesn't matter whether a conviction is imposed or not. It's still, for the purposes of that order, any finding of guilt is considered a conviction. The same for the purposes of appeals or variations or contraventions of sentence or any subsequent offending. Any finding of guilt by the court will amount to a conviction for the purposes of those provisions, but it won't count as a conviction for other acts. So, for example, you cannot join many organisations if you have a criminal conviction. When they do a security check, a finding of guilt, such as a fine without conviction, the not paying for parking illegally, is not going to show up as a conviction. It will show up on a criminal history check and a criminal record check, but it won't show up as a conviction. So, people aren't going to be stopped from being firefighters or paramedics because they have a finding of guilt for a parking fine. However, if they do it multiple times, the conviction may later be imposed, and all of those previous ones are still put before the court as part of their record. And when imposing a conviction, the court needs to consider the nature of the offence, the character and past history of the offender, and the impact of recording a conviction on their economic and social well-being and employment prospects. The nature of the offence, for a lot of you work for councils, the types of things that you may prosecute come in a really broad range of seriousness, and a court is going to look at the nature of the offence that they've committed, not just the maximum penalty. So something like a planning offence, where there is one single offence that covers everything from keeping a building site operating after hours to illegal demolition of a heritage building, the court's going to look at the actual facts rather than just the maximum penalty in determining the nature of the offence and whether to impose a conviction. And the character and past history of the offenders, pretty self-explanatory. A person with no prior criminal matters, who's of good character and been a good member of society, is less likely to have a conviction imposed than a person who has prior criminal matters. It is extremely rare for a conviction to be imposed on a first-time offender, particularly for an offence without injury. So obviously everyone commits a first offence, and if it's very serious and hurts somebody else, then they'll have a conviction imposed. But it's not unheard of for people who've committed aggravated burglaries, for people who've committed armed robbery, for people who've committed sexual offending, not to have a conviction imposed on their first offence in certain circumstances. So in those, magistrates know all of that, and so they're going to be much less likely to impose a conviction on a case where they view the nature of the offending and the prior good character is really high, knowing that it might be the most serious thing that your organisation prosecutes, but it may not be that serious to a magistrate, considering all of the other things they deal with. And the impact of recording a conviction is really important. If a conviction is recorded, a person is unlikely to be able to apply for certain jobs. They may not be able to travel to certain countries, particularly China and the US have really strict rules on convictions having to be declared. They may not be able to work with children in certain circumstances. Some schools and other organisations are really strict, and more than just a working with children's check, they require that a person has no prior criminal matters. So the court's going to really consider whether a builder who worked on site late needs a conviction imposed when it's not going to allow them to go to their son's soccer practice anymore. So you have to be aware of those things and the circumstances of the offender if you're going to make an argument about conviction. On the topic of making an argument about conviction, it's not for the prosecutor to argue for or against a conviction. It's a discretion of the court. All the prosecutor can do is make submissions about the facts and circumstances, comparing it to other cases, and say that a conviction is warranted or that a non-conviction would be manifestly inadequate. It's a difficult argument to make if the court's against you. And unless you have really strong instructions about conviction, or defense is pushing really strongly for non-conviction in circumstances where comparable cases and the facts of the case make it warranted, usually the court will not seek your input on conviction. It's a matter for defence sort of to argue. If defence does put something about a conviction that you disagree with, then by all means say, but it's not, for the prosecutor to argue for a conviction. All right, then we come to instinctive synthesis, which is how the court determines its sentence, which is where it all does start to get a little bit mystical. The court is asked to consider all of these competing facts and considerations and what the prosecutor has said and defence, and then by virtue of their position as a judicial officer, decide on what the appropriate sentence is. It's not numerical, it is guided by other cases, but not, bound to them. And as long as it's reasonable and pays attention to all the facts that have been put before the court and the relevant legal provisions, then it's going to be correct. And the purposes for which the sentence is imposed is sort of the guidelines that the judge is using to structure that synthesis. So under the Sentencing Act, the purposes for sentence are to punish the offender in a just manner, to deter the offender or other persons from committing the offence. And so that's where we talk about specific deterrence of the offender or general deterrence of the community from committing the offences, to rehabilitate the offender. And that's where the programs and courses and things like that are really important. To denounce the type of conduct. So this is where more serious offences get more serious sentences, because we're denouncing to the community, or the court's denouncing to the community, that this is not appropriate. To protect the community. And all of those factors are what the judge considers, and they impose sentence to meet those purposes. So if you are making sentencing submissions, you would make submissions that, an accused who's done this 5 times before needs to be specifically deterred from doing it again. It's, offences that put people at risk. It's like necessary to protect the community from the offender engaging in this type of conduct again. So you use those purposes of sentence to direct the court or to assist the court in what facts are most important. And finally, after a sentence is imposed, it's likely that neither party will be entirely happy with it. The prosecution can only appeal to the court appeal the sentence if it's manifestly inadequate as a matter of law. So if it's merciful, light on, that's not going to be enough. It needs to be erroneous. It needs to be so outside of what is expected and what's happened in other cases, that as a matter of law, it's manifestly inadequate, and then it can be appealed. The accused doesn't have those same constraints. They can appeal either a conviction or a sentence that they are on any grounds that they're unhappy with it. If it's a decision by a judicial registrar, it goes to a rehearing by a magistrate. If it's a decision by a magistrate, it's an appeal de novo to the county court. An appeal de novo means that it's basically a rehearing by the county court. So any withdrawal of charges, any changes to submissions, things like that were made in the magistrates court need to be remade in the county court, because the county court is actually revisiting the whole exercise that the magistrates court did. So if you do have a matter appealed to the county court, you need to be aware that it's de novo or new, and not just on the sort of consolidated basis that might have happened after discussions. After county court, you could appeal to the Supreme Court on a question of law. And separate from that procedure, you can also have judicial review, which is where the Supreme Court will consider whether the magistrate made an erroneous decision, not on the sentence and conviction, but on the actual exercise of their powers. And that might occur sort of innocently, where a judicial registrar dealt with a matter that they didn't have jurisdiction to deal with, or where the magistrates ruled in or out certain evidence, or made certain decisions about charges that the defence argues is outside of the scope of their power. Improper conduct by the prosecutor at any stage is grounds for an appeal, and that can include things like the prosecutor being, making erroneous, like improper suggestions, making submissions to the court on facts that are not supported by evidence, charges proceeding where there's no evidence to support them, or just the general conduct of the prosecutor. Your duty is to the court and to the administration of justice on a plea and sentence. It is not to advance the political interests of your organisation or to seek justice and vengeance, no matter how much the informant might think the offender is the worst person in the world. You have to be fair, you have to be calm, you have to understand that for many accused, this is the worst thing that's ever happened to them, as much as it might be the worst thing that's ever happened for any victim. It can be a confronting process. They may have spent a lot of money on legal fees, and it's not for the prosecutor to gloat over those things or to be unduly harsh where it's not warranted, or, well, it's never warranted to be unduly harsh, but in your manner, in the way that you conduct the plea, it's to be fair and to be exercising that duty to the court. Additionally, if the way that the case is run in the magistrates court is generally how it needs to be run the whole way through. You can't, if there is an appeal, the prosecutor can't turn around and change the whole case or rely on different evidence. You need to run the matter properly, make sure all the submissions are made, all the facts are pointed out, all the evidence is before the court, because if it does then go further on appeal, what happened in the first instance is constraints on what can happen, what the prosecutor can say or rely on later on. And that's the basic sort of run through of the structure of a plea and sentence in the magistrates court. I see we've got one question, and that is, what if the court withdraws the charge without the prosecution present? Can the prosecution refile? Yes, so if a charge is withdrawn, it can be in any circumstances, it can be refiled if it's within time and they haven't been dealt with for those on those facts before. However, the court withdrawing the charge without an application by the prosecutor, so if the prosecutor is not present in court, is probably judicial error. The court on its own motion can't withdraw a charge because a charge is brought by the informant and they can seek that it be withdrawn and struck out. The court can strike out a charge if the prosecutor fails to appear. And then you've probably got some more serious questions to answer about why the prosecution didn't appear when you're refiling. So technically you could refile, and if there's been some error or issue, and that's why it was struck out, you can refile or file a different charge that's, meets whatever problem the court had with it. But if the court's, acting on its own motion and the prosecution didn't appear and make the application, then you need to consider whether there's actually a judicial review question in there because the court's acted outside its power. And yes, Michael is right. The new, so local laws passed under the 2020 Act. So if you've got a local law that's come into effect sort of, made in 2021 or whatever, then they are indexed with penalty units. All the local laws, so if you've got a general law from General Law 2018 or something like that, that's still going to be subject to 100 penalty units. And everyone's answered that question. Heidi, yes, the prosecution can put submissions on sentence. You just have to be careful in how it's worded. So you're talking about directing the court as to comparable cases. You're directing the court as to how serious the offence is on the facts and circumstances, what sentences might, so if defence is asking for something that you say would be manifestly inadequate, so say you've got a dog that's attacked someone and defence wants the charge proven and dismissed, you'd be saying that's manifestly inadequate because similar cases, terms of imprisonment have been imposed. But you can talk about a fine being reasonable in all the circumstances, but you can't direct the court as to an amount of a fine or a term of imprisonment or something like that. You can tell them what the maximum penalty is. You can tell them what the infringement penalty is. You're informing the court as to the facts and circumstances, not directing them to impose a particular penalty. In terms of referring to uncharged acts, you need to flag that they're uncharged. So whether they're uncharged because the charge has been withdrawn, and that would usually be something you'd agree with defense. So if you're withdrawing charge 2, but you want some of the facts in, you would negotiate that as part of the resolution with defense. Say, well, all right, charge 2 is withdrawn, but we're going to refer to the fact that the dog was uncollared, and they'll agree to that or not. If it's an uncharged act that, never formed part of the case, then it shouldn't form part of the summary. If it's an aggravating factor and you need it in there, it either needs to be a charge, or it could go in as you make a really strong argument, and you'll have to make the argument both to defense when they read the summary and ask for it to go out, and to the court that it's relevant to the context of the offending. But if it's something that you really need to rely on, so if you're relying on it as, a prior offence that they've, and now this is a subsequent offence, you need to explain why it wasn't charged, because the court can't, say they did something 2 years ago and they were never charged for it. The court can't consider that the new offending is a subsequent offence, because that first offence, they're not guilty of it. They were never found guilty of it. So it's not, the new offence isn't a subsequent offence. But if you're talking about that they'd been issued infringement notices before that they'd paid, and now they've done something worse and they've been charged, then that's certainly something that you can reference, because it's they've been dealt with it for. In terms of negotiating with an accused for their costs not being sought, so the accused can't seek costs unless they're successful. So if you're worried that you're going to lose a contest, then you should have a serious look at the charges. But if you think you're going to be successful in contest, then that the accused wouldn't be able to seek costs. But if you are worried about proceeding to contest, then yes, that can be part of discussions with the accused, that they'll plead guilty to some charges, and some charges will be withdrawn. If most of the charges are proceeding, then they're not really considered a successful accused for the purpose of making a cost application anyway. But if you're, withdrawing all the serious charges and proceeding on one charge, then they may make a successful cost application. So yeah, that's when it would be part of your negotiation. But you do often get in criminal matters where the other side is a civil lawyer, called a black letters, which is like basically agree with what we say, or we'll tender this letter in a cost application. Defense can only make a cost application if they're successful. And if they plead guilty, then the court is unlikely to consider them successful unless a lot of the charges have been withdrawn or serious charges have been withdrawn. So, I wouldn't, it can come on quite strongly, particularly from civil barristers, this whole costs issue that they're going to seek costs. But if they're not successful, they can't seek costs. So it shouldn't form a huge basis for why you would resolve a matter unless you are really concerned about them being successful. Jared's question about diversion notices is, if both parties agree to a diversion notice and then the court changes the conditions, can the prosecution withdraw their consent for the diversion? Yes, you can. So when you put through your diversion notice to the court with the conditions you're seeking, if you turn up and the magistrate is like, I don't like those conditions, I'm going to impose something else, you can say, well, the prosecution no longer consents to the diversion. as a matter of course, if the conditions are unreasonable, then you're not bound by them. Though you do have to consider that if you withdraw the diversion and it goes before the court, if they plead guilty, they're likely to get an adjourned undertaking on the conditions that the magistrate originally wanted to impose on the diversion. So it's a circumstance where it's probably better to try and make submissions to the court on why the original conditions were appropriate. And I had one recently where the diversion condition was agreed that they would write an apology letter. The court said, I don't think that's reasonable. You know, I don't consider that the person who you were writing the letter to is a real victim. And we just made submissions saying, look, you know, the person was severely affected by the offender.